Good afternoon. I see Senator Carney isn't here, but Representative Kuhn and other distinguished members of the Joint Standing Committee on Judiciary. My name is Lieutenant Michael Johnston, and I'm here to represent the Maine State Police and the Maine Department of Public Safety to testify in opposition of LD 1378. Probably won't have time to read my entire testimony, so I'll try to cover the high points and answer any questions or try to be responsive to the questions you have. So as of June 10th, there have been 881, so there's one additional one, so you can add that to the testimony. So there have been 881 successful yellow flag applications since the tragic events that occurred in Lewiston. There were 81 total in the 3.5 years preceding Lewiston. This increase represents a few important things. Chief among them is that the current yellow flag law is working. So I am the principal instructor on the yellow flag law for the Maine State Police. I was also part of the public safety team involved with the implementation of the yellow flag law when it went into effect on July 1st, 2020. The state police have successfully applied for a yellow flag order 90 times since the law went into effect, the most of any law enforcement agency in Maine. My troop alone, I command the Northern Field Troop, has had over 50 successful applications. I have seen firsthand how the law can be effectively implemented to ensure the safety of the respondents, their family, and the public. While the new law can always be improved upon, we feel that the passage of the public law, Chapter 675, that was passed last year, improved and strengthened the existing yellow flag. I have concerns that the proposed legislation, if passed, will potentially undermine and detract from the law that is currently working. Under the language of this bill, a law enforcement officer, law enforcement agency, family, or household member can petition the court for a red flag order. The standard for receiving an order is showing the respondent poses a significant danger of causing physical injury to the respondent or another person by purchasing, possessing, or receiving a dangerous weapon, or by having or attempting to have custody or control of a dangerous weapon. I'm not sure what this bill seeks to prevent that is not already covered by existing statutes under our Criminal Code, Title 17A, under the Protection from Abuse Order statutes, under Title 19A, under our Protection from Harassment Order statutes, under Title 5, and our current yellow flag law, under Title 34B, 3862-A. Under the current yellow flag law, third-party members such as family or household members, friends, colleagues, community members, and mental health professionals can already initiate this process by reporting their concerns to law enforcement. And the data shows that this happens every day, sometimes multiple days across the state. It's been my experience that those reporting parties are crucial to the utilization of this law, as they are often the people calling law enforcement to report their concerns and request a welfare check. Their reports provide the legal and factual basis to initiate this process. Pursuant to 3862, when formulating probable cause to take a person into protective custody, we may rely upon information provided by third parties, as long as it's credible and reliable.
I'm sorry to interrupt you. Can you summarize or wrap up your testimony in just a sentence or two, and then I imagine there'll be questions.
Sure. So the rest of my testimony talks about the public safety concerns I have with service of these orders. Service of these orders will be extremely high risk. Under the yellow flag law, we have the opportunity to serve the person in the confines of a hospital and then work with family members on the relinquishment of firearms. Under this proposed bill, we would be going to that residence and serving these orders and taking relinquishment of weapons after there've been a finding of dangerousness. So I think this is going to be a heightened risk of service for law enforcement and for the respondent, because it's going to be dangerous to serve them.
Okay, thank you. Let's see if there are any questions. Representative Poirier.
Thank you, Madam Chair, and thank you so much for coming here. I've been looking at some of the parts of the testimony that you didn't get a chance to read, but I would like to have you elaborate a little bit more. There's a real concern that I see here that you show concern about, as well, as far as creating confusion with domestic violence, siphoning resources, that sort of thing. I'd like you to elaborate on that, and also the dangers that you're just talking about for law enforcement. Can you talk a little bit more about that?
So I have a lot of familiarity with the protection from abuse and protection from harassment order statutes. All law enforcement do. They're critical tools to protecting victims in domestic violence. So when you look at Title 19A, Chapter 103, where the protection from abuse order statutes are codified, and you look at the eligibility, who can petition the court to get that? It's family and household members. And when you look at the definition of abuse under 19A 4102, it lists all sorts of things that fall under abuse, which mirror a lot of the provisions in this statute. So I guess one of my concerns would be is if you're a family or household member looking for potential relief, are you pursuing the 19A remedy? Are you pursuing this new potential statute? Does it muddy the waters? Does it siphon resources from one to the other? Protection from abuse orders are critically important tools that law enforcement serves expeditiously, that has a firearm relinquishment provision. So I'm concerned about what is the harm that we're seeking to prevent that isn't already covered there, and does it potentially confuse things, or do you get diminishing returns if you have similar processes in place and people aren't sure which ones to take advantage of?
Follow up?
Yep, go ahead.
Thank you. So under the current yellow flag law, there is that protective custody component.
Yes.
Do you feel that that alleviates these concerns that you're discussing as far as like maybe some domestic violence issues or the police, law enforcement being put in a situation where they could be endangered? Do you think that having that protective custody component keeps everybody in the scenario more safe?
Yeah, so the current statute requires us to have probable cause to take a person in protective custody. So on the yellow flag, we are involved on the front end. We are called by family, or we are requested by a friend or a practitioner to do a welfare check. Oftentimes, in my experience, it's the family members who are calling us already with a concern for their child or their husband. And we respond and we talk to them and we talk to the person on the front end, and we're able to do an investigation and determine, okay, do we meet the elements of the statute? Can we take them into custody, deliver them to a hospital, have them examined by a medical practitioner? And then that ends up being a lot safer when we need to remove firearms than if we were to sign on shift and say you have a red flag order that you need to serve, and there's been a finding of dangerousness and no interaction by law enforcement with us or the family. We have to go there cold and try to safely and effectively serve this order.
Thank you.
Thank you. Senator Talbot Ross, did you have a question?
Yeah.
Mike.
Thank you so much, Madam Chair. Lieutenant, thank you very, very much for being here. And I'll go through your testimony a little bit more in detail since it is so dense. But I just have one or two questions, really, if allowable. And one is, we've heard that part of the concern with just having a yellow flag law available is that some family members, for whatever reason, are just not comfortable going to law enforcement to seek that kind of request, that kind of protection. Can you speak to that? And the context is, we heard from the Maine Gun Safety Coalition that this is not a competing measure with yellow flag, like your testimony suggests, that people would be confused, but it is an additional tool available to those family members, particularly who are not comfortable going directly to law enforcement. So could you please address that?
Sure, thanks for the question. So reference your first question, whether family or household members are reluctant to call law enforcement, and as a result of that reluctance, the yellow flag process would not be initiated. That has not been my experience. My experience with the over 50 applications my troop has done, the vast majority of them are initiated because a family member has contacted us. Either a family member has been in crisis and we're responding out there, or they've contacted us because they've had concerns about the behavior of their family member, and they're asking us for help, and we go and we interview them and get the information. So with this law, as I understand it, if it were to pass, law enforcement's still involved. We're just not involved on the front end. So if a yellow flag order was obtained because a family or household member petitioned the court, probably one of the first things I'm going to ask my trooper to do when they get that order is to call the family member. That's what we do on PFAs. We contact the plaintiff and say, is there any other information that we're missing or anything else that you can tell us about this to help us safely execute this order to relinquish the weapons. And then we're still involved on the back end. Law enforcement is still responding to the residents to relinquish the firearms after the family member obtains the order.
Go ahead.
I'll be a tiny bit more direct with my question. Thank you for that answer. I guess my question is, what is the harm in giving another tool to family members like this bill suggests? Another tool, not a confusing one, another tool for family members to use if they are not comfortable going directly to law enforcement. What is the harm in making that tool available?
So in my testimony, I talk about how In 3.5 years, there was only 81 yellow flag applications, and I think that's attributable to a number of things. We had some issues with medical practitioner buy-in early on, and then I think Lewiston was a wake-up call for everyone to include law enforcement, and there's been 800 yellow flag applications since Lewiston, when there was only 81 in the 3.5 years. That speaks to law enforcement. It was a wake-up call for everyone. Renewed focus on training, on accountability, on using this tool, and law enforcement is doing that. So I think when you add another tool potentially to the tool chest that arguably I don't think addresses the harms that are already addressed, then I think it can detract or diminish from what's already working. It can siphon resources away from that. And I guess, and as part of the answer to that, what is the harm in it? One of the things I put in my testimony, and this is a process thing, if law enforcement petitions the court, normally it's the petitioner that has to show up at the hearing and defend the petition. Well, that's generally lawyers' work. Under the yellow flag law, the district attorney's office is the one who handles the yellow flag orders. If a law enforcement officer petitioned the courts, it's incumbent on the law enforcement officer within 13 days of an emergency order to show up in court and defend that petition. And you have some small agencies and small departments that are it's going to be very resource dependent. So that's more of a process issue. But when I look at what the yellow flag is doing, it's working very well. Our opinion is strengthen it, refine it, like it was last session when it added the protective custody assessment, it added a reciprocity provision, focus on continued training and development for police officers on effectively using the law. I just think it's been said here today, law enforcement officers are strained with resources, and you add additional statutes that I think it's arguable whether or not it addresses the harms we're seeking to prevent, and it can have diminishing returns, particularly on something that could be as resource heavy as a red flag.
Okay.
So I don't know if that answers your question, ma'am. Okay.
Let's see if there are other questions. Representative Lee?
Thank you. I kind of went on a language adventure, as I'm prone to do. And last session, the red flag bill that we received had a firearms relinquishment order, specifically just firearms. This one has dangerous weapons, but dangerous weapons is also in the yellow flag law. And so I looked at what the definition of dangerous weapons is, and it's a firearm or any device designed as a weapon and capable of producing death or serious bodily injury. When you're teaching law enforcement officers how to enforce the yellow flag law, what do you tell them comprises a dangerous weapon?
So we look at the statute. So you're probably looking at 17A, Section 2, subsection 9, paragraph C. So we tell them that it's a firearm, or we tell them it's anything, an object, animate or inanimate, that in the manner which it's threatened to be used can cause death or serious bodily injury. So there's a contextual aspect to it. So let me give you an example. If we go to a residence under a yellow flag and someone we think has a mental illness and presents a likelihood of serious harm to themselves, and they're saying they're going to use a knife to cut their wrists, and let's say it's a steak knife. A steak knife ordinarily is not a dangerous weapon, but when you threaten to slit your wrist with it, in that context, it's a dangerous weapon. So that would be a yellow flag for that purposes. Firearm always is. Other things can be. It depends on the context in which it's threatened to be used.
Thank you. Quick follow-up, we have a lot of questions.
So that means when you go in on a yellow flag, you're not just taking everybody's steak knives?
No, we're not. So that's a question that come up. We don't seize all the cutlery in the house, and I don't mean to make light of that, but no, because not everything is a dangerous weapon. If they said, yeah, that knife or a knife, but we're not taking every baseball bat, we're not taking every hammer, we're certainly taking every firearm, because a firearm by law is a dangerous weapon, always.
Thank you. Senator Carney?
Thank you, Chair Kuhn. Thank you for being with us and for your testimony. I was just wondering if you could help us out with a little bit more information about the yellow flag application. So in your testimony, you stated that there have been 880 applications since the Lewiston massacre. How many unsuccessful applications have there been during that same time frame?
So I think there's been 800 since Lewiston. There's been 881 total since the law went into effect. I think there's been one that I wasn't able to update my testimony with. There's been 881 total. I think there were 81 successful from July 1st, 2020 to Lewiston. Since Lewiston, there's been 800.
Yeah, and I guess I'm asking you how many unsuccessful. So I'm assuming that sometimes you seek a yellow flag order and you they don't,
Yes.
aren't given. Can you
Yes.
let us know for
So,
the same
my-
timeframes outlined in your.
My
testimony.
experience is anecdotal. I don't have the statewide numbers, and if that's being looked at or tracked on a temporary application, because you have you'd have the temporary restriction, which 30 days, and then you go to hearing, and then a judge would have to determine by clear and convincing. So I don't have the exact numbers on the denials of the temporary or the ones that go to full hearing. In my experience, there's been, I think, 2 times that my troop has tried to do a yellow flag, and it wasn't approved.
Was that the temporary or
The temporary, yes,
so you've had 2 unsuccessful temporaries?
yes.
And do you know the information for the remainder of the state?
I don't have that information center. I don't know if that's being tracked. I know there are a bunch of people in the state that look at yellow flag, but I know that.
Could you ask the people who are tracking yellow flag?
Sure.
To provide that
I can check
information?
maybe with Spurwink. They do the lion's share of the initial assessments, so that may be information I'll check with them and see if we can provide that to you.
Yeah, or you can, I mean, whatever source of information you had for the successful applications, I'm assuming they would also have applications that weren't successful.
So that's a list provided me of successful yellow flag. I don't think it includes the ones that weren't, but I'll double check.
Thank you.
Thank you. And you could email that information to the
Sure.
committee. Next up was someone over here, Representative O'Halloran.
I think you're not.
You need to put your mic on. There it goes.
Thank you for coming today. I'm just trying to understand because this is all new because obviously we don't do your job and I don't think I could anyways, but my understanding from what you're saying today on a yellow flag call, you will oftentimes like speak to the person who made the filed the complaint, and then you'll go in and then you remove the person and then you go in and get the weapons. Is that what you were saying?
Generally speaking, that's probably not. There's a garden variety yellow flag, but yes, the family calls. We go. We do an investigation. We take the person into protective custody. There's a dangerous weapon aspect. We have them examined by a medical practitioner, and then we work with the family on the relinquishment of firearms.
And the difference from that is, and I'm sure you also ask them if there's any other firearms, any other place, and then they also have to sign paperwork stating that there aren't any other firearms, and if they're lying, there's consequences for that as well.
Potentially, yes. I mean, potentially.
And so the difference between a yellow and a red flag law, from my understanding, what you're trying to say today is that with the red flag, you're showing up and removing the weapons while they're still there. Is that what you're saying?
Yes.
And then that's what makes it a more dangerous situation for law enforcement.
Yes, that could certainly result in a confrontation. We're not taking them into protective custody. We're not taking them under arrest. We're just there to serve them with the order and take possession of their firearms or dangerous weapons.
I'll ask a follow-up question. Do you need to go and retrieve those while the person is home? Or are you permitted with your warrant to enter the premises when the person is not home?
So there's no warrant provision for this statute.
Sorry,
There's
no order.
there's no civil provision to get a search warrant. So there really is no legal basis to enter the residence. So I suppose if we were to go there, and it's similar to sometimes a protection from abuse order, but that if we went there and we had to serve them an order, there's a trust but almost no verification process. That order doesn't carry with it the authority to go into the residence and see if there are firearms. We'd have to serve the order. Then subsequent to the service of the order, we'd have to have probable cause that they remain in possession of firearms. And only then could we get a Rule 41 warrant, which is a criminal search warrant.
Thank you. Representative Poirier.
Thank you, Madam Chair. I think this is my last question for you. You had talked briefly about strengthening current law. Would that include things like resources for additional training? I'm sure it's harder for like smaller departments to gain access to training, like larger departments do that sort of thing, and also like mental health, telehealth, that sort of thing.
Yes, so I think it's not just focused on the training of the yellow flag, but addressing the underlying issue, which is mental health treatment. So yes, it would be training for law enforcement. It would be more crisis receiving centers. It would be bolstering community-based mental health treatment resources to kind of holistically address it. But continued focus on the yellow flag, continued training for law enforcement officers.
Thank you. I am considering very strongly a competing measure, so that information is very helpful. And Eli, I would like to discuss that with you later if that's okay.
All right, any other questions, Senator Hagan?
Thank you very much. And thank you for everything. All right, well, now I'm intrigued about red flag procedure. I hadn't really gone through any of that. So could you walk me through A through B, A, B, C, D, E? There's no warrant under the red flag is what I'm getting. You serve the order and you just go in and get the guns, and then you leave the person there, then you just drive away, impound the guns, and that's it.
Yeah, I mean, yes. Essentially, if, as I understand the statute, if we were to serve one of these, we go there, we serve the party, we take possession of any firearms or dangerous weapons that we're aware of that they possess, we store those, and we leave and we drive away.
Follow up?
And I hear all the time that the storage in law enforcement facilities is generally a steel locker out back. So by the time they get their guns back or firearms, what have you, if they do, they would be all rusted and pitted. It's not like a climate controlled spot.
So yeah, this is
Point of order?
Yeah.
That
Senator
didn't,
Carney?
to me, it didn't seem like a question. It seemed like facts that Senator Hagan was injecting into the conversation. Thank you.
I wasn't trying to do that.
All
I
right,
just want to know.
if you have a question, you can go ahead and ask it.
Well, I just want, that's my question then. Is that
All right. Do you have a
what
response
happens
to
to the
that?
guns?
Thank you, Representative Babin.
So the state police, at least my troop, is blessed to have good storage facilities, but I serve on the another committee that looks at storage, particularly related to firearms through protection from abuse order. So storage of firearms is a practical problem. I know some police departments aren't as well resourced. They may have a glorified storage closet serving as both an evidence locker and firearm storage. And there's a state law under Title 25, 2804 that says we need to keep firearms in pristine condition, and they need to be returned in the condition we take them from. So if you're serving multiple orders and you're taking a couple hundred guns a month for protection from abuse orders, criminal search warrants, and red flag, storage becomes a practical problem.
Thank you.
All right. Any final questions, committee members? Representative Caruso.
Madam Chair, thank you, sir, for your testimony. I have a couple of questions. One of the members of the public who testified earlier said that the red flag law would reduce the burden on law enforcement. I'm assuming she was referring to time and trips to visit members of the public, as if the yellow flag law would be more burdensome than the red flag law. And I was wondering if you could speak to that. Is that true?
So as I understand this testimony is drafted, I think it would be more burdensome for law enforcement. And I've outlined some of it in my testimony when I look at the statute and some of the process related issues. If we're continuing to do 400 to 500 yellow flags, and that increases a year, plus you add that to the process, then that can be difficult. That can strain law enforcement officers. But when I look at this, is essentially overlaying the protection from abuse order civil scheme onto the red flag, where law enforcement is now a petitioner. We're petitioning the court. We have to file we have to file the forms with the court. We have to go to the temporary hearing or the hearing for the court. We have to essentially defend it. And I view that as more lawyers' work outside the scope of our training and expertise. You have to do it within 14 days, so there's a quick turnaround. And when I think of, most police agencies in Maine are less than 10 people or less, and you're having them doing work that they may not be qualified for in a quick turnaround, I think that we have concerns about that, and I indicated that in my testimony.
Thank you. Did you have a follow-up?
Yes, I do. I have a different question, but can you say that you have to file the petition? You have to write the petition.
Yeah, so if you look at the statute, it defines petitioner, it defines it as either a household or family member, a law enforcement officer, or a law enforcement agency. And then it cites what the definition of a law enforcement officer is, and it takes you to Title 25. It is not a prosecutor or district attorney. It is a police officer. So we have to petition the court But it's not necessarily the initial petition to the court, like you would do with a search warrant or a yellow flag application. It's when that goes to hearing. We're the petitioner. We filed for the court as to why this order should be in effect. We have to show up at the court hearing and have to handle that petition. The prosecutor is not the right word for it because it's not a prosecution, but essentially prosecute or litigate that petition. And, the judge's decision may rise and fall on what the law enforcement is presenting. Normally when we show up to matters like that, we're a witness. And the DA is handling it, like in the current yellow flag.
Right.
So that court process is concerning for us and what that actually looks like.
Thank you. Any further questions? Representative O'Halloran.
Oh, sorry. So I'm just trying to get clarification on my end too, because we've heard some different testimony. So would it be the judge that originally under the under the red flag law, wouldn't it be the judge that already makes that determination before you go?
So as I understand the proposed legislation, if you're applying for an emergency extreme risk protection order or an ex parte order, then you're going to go to a judge and you're going to say, we need a red flag against this person. And law enforcement would have to fill out an application and meet the elements of the statute. And then a judge or justice of the peace would look at it and then sign off on it. But then they're going to set that for hearing within 14 days. And they're going to look at the merits of the case and evaluate. I suppose it's a due process. So at that point, law enforcement has to show up and kind of present their case more fully.
Okay, I got that. I thought I understood from some previous testimony that a judge had already made that decision. So that's why I was asking.
A judge will make the decision after evidence is presented, I think, by both sides, and law enforcement would be representing.
Prior. So that's why I was asking for, thank you.
All right, Representative Poirier, are you all set?
Just a quick one.
Okay.
Just for clarification, this question brought me to another one. So with the red flag, you're talking about 14 days. So is that 14 days before anything's even done when somebody files under red flag? My question is basically, if it's 14 days after you file for a red flag, what is the turnaround time per se versus yellow flag? Is one going to help quicker than the other?
Well, as I understand the proposed language, that if you get an emergency order on someone, they're entitled to have a hearing in court within 14 days. Now, under the yellow flag, if you get a yellow flag against someone, there's a court hearing within 30 days. They expanded it last session from 10 to 30 to give a little bit more time, I think, for prosecutors and law enforcement to prepare for that hearing so they could put their best foot forward, and probably also the patient or the respondent as well. So it's just, once you serve someone with an order, now they say, we're going to have a full hearing on this within 14 days. For the red flag, it's 30 for the yellow flag.
Just to clarify on that. So if a person's firearms are being taken away, the yellow versus red, is one quicker than the other?
Yeah. So I think you have a hearing within 14 days under the language here. It's 30 days with yellow flag.
And nothing's done before that hearing?
Correct. It's a temporary restriction.
Senator Carney.
Are you speaking about the temporary restriction or the order that the court would issue after a contested hearing?
So just on quick, I know it's yellow flag, red flag.
Just a moment, if you can. Your mic is off again. I'm not sure why.
Mine's off. It wasn't me this time.
So just, I think everyone understands, but obviously red flag and yellow flag are kind of colloquial terms. So the yellow flag is what we have now. The red flag is what's being proposed. So right now under yellow flag, if I'm able to successfully get a yellow flag order, that is a temporary order. It is temporary restrictions that last for 30 days. So during that 30-day period, that person is prohibited from possessing or controlling dangerous weapons. Within 30 days, they are entitled to a hearing. And at that hearing is when the DA would show up and the respondent would be there represented by counsel, and a judge would have a full hearing on it. So that is the temporary restrictions. After the full hearing, there's a number of things that can happen. A judge can decide if he finds by clear and convincing evidence, he can restrict that person for up to a year after the full hearing under the yellow flag. So I think there are some similar time requirements in the red flag, but I don't know if that answers your question.
Representative Henderson.
Thank you, Madam Chair, and thank you, Lieutenant Johnston, for being here. I know we've met before. I just can't recall when it was. So when you refer to the term serving them an order or a successful order, you're referring to whether it's under the yellow flag law, going in and bringing the person into custody to have a mental health evaluation, which is under yellow flag, or you're referring to under red flag when you say serve them the order or successful order. That seems to be the beginning process when law enforcement is making interaction with the person in question and is going into the home to remove the guns. So the 14-day period or the 30-day period in their respective flag orders, those periods begin once law enforcement on red flag has either removed the firearms or under yellow flag has brought a person in for mental health evaluation. So the firearms are removed already when that 14-day period begins. Am I understanding that correctly?
Sort of. I just want to make sure I answer your question and be clear. The restrictions begin under the yellow flag when the respondent is served with a notice of restriction after it's been signed by a judge. That is when it starts. And that has happened after the law enforcement officer has taken them into protective custody and after a medical practitioner has done an evaluation and after the judge or justice of the peace has reviewed it and signed it. Then law enforcement serves the person with a notice of restriction. At that moment of service, they are prohibited from having weapons for 30 days until they have a hearing. Right. And I think it's similar with the red flag. Obviously, they don't have the medical practitioner piece and the protective custody piece, but my understanding is that the restriction, when they are legally restricted from having firearms, starts at the moment they are served.
And then that begins follow-up, if I may.
Okay.
That begins that 14-day period that you're referring to.
Correct.
Okay.
Yes.
Thank you.
Representative Caruso?
I remembered my other question. So, and it kind of goes along with Representative Henderson's conversation with you. There has been a concern that voiced to me that with the red flag, it could be used as kind of in domestic spats, where someone wants to get back at, like, say, a girlfriend at the boyfriend or something, and will, say something that would instigate a red flag and you coming to the door and removing guns. And I wanted to get your take on that, if that's true. And then one other thing I'd like you to address is there any justification, like if there, in the yellow flag, you have a medical examination, you have some kind of justification for taking firearms, from what I understand. And from what I understand, that's not there for the red flag. Is that accurate?
So it sounds like there's two questions. Reference the first question. Certainly any law can be abused. Any process can be abused. I think what I would distinguish about this is when law enforcement is involved on our front end and this process comes from a law enforcement investigation, you have law enforcement as kind of a fact finder that can conduct interviews, look at evidence, look at criminal history, talk to witnesses, kind of weigh their veracity, their credibility and reliability. If people think that that's a safeguard or a check, then fine. I think there's abuse with any law and any process, but I think when you have law enforcement that are professionally trained doing their job and doing a thorough investigation, some may view that as a potential check on maybe that abuse process. What was your second question, ma'am?
So is that's not there with the red flag?
So the law enforcement investigation is not, no, because they are petitioning the court directly. Law enforcement only becomes involved when the court issues the order, and our role is to serve it and try to take possession of the weapons.
Right. So without having justification, it could be he said, she said kind of thing, and it may not be true because you're already coming to the door no matter what.
Right. I mean, the way we look at it is if a judge issues a signed order, we're going to issue the order. We're not going to dig into the merits of it. So on protection orders, we're not involved with that process. A judge issues it and we show up and we try to serve it. That's our role as expeditiously as possible. So we don't dig through it and dig into the merits of it. That's really not our role. So I guess on the red flag, we wouldn't be doing that either. We'd certainly look at it to make sure how do we effectively and safely serve this, but we wouldn't be kind of relitigating and saying, well, that's not true. We don't think that's true. That once a judge has signed it, that wouldn't be our role.
Can I have one final question?
Okay.
Sorry. Have you thought, or has anyone thought about if this were to come to pass, if the red law were to come to pass, what the demand would be on your resources in terms of if now the officer has to be litigant, has to take the place of the DA, the Attorney General?
Yeah, district attorney does the yellow flags now.
Okay.
Yes.
Yeah. So if now your law enforcement officers would be the one that has to file the petition to go to court, to be the litigant, all of that, whereas they didn't before, they were just a witness. Have you thought about what that would do to your resources?
So the state police, we're fortunate. We're fairly well resourced, although we're strained at times. It would be very, very difficult for us. I couldn't imagine how it might be for a smaller agency where you might have one or two officers working all the time, limited budgets, calling them in on overtime to go to court. So, but from a resource standpoint, speaking from the state police and Department of Public Safety, it would be significant just for us. When I look at the high-risk nature of the service of these orders, we would likely need additional negotiators, maybe additional potential high-risk tactical team operators, because these oftentimes can turn into situations that are very confrontational and can be barricaded, even though we don't want them to. So, we think that there would be a significant fiscal note for the state police, and I can't speak for every other law enforcement agency, but I think it would strain them.
Senator Hagan?
I thought about it last night, but I kind of let it go until the process and then that. So SWAT would probably, under red flag, be utilized much, much more, and you would need more people.
Yes, yeah, we have requested a fiscal note on this bill that includes additional negotiators, because it's always best to negotiate people out. But our concern is if there's a finding of dangerousness by the court, and also a finding by a preponderance that they possess or control dangerous weapons, and we're going to the residence, that could very well provoke a confrontation and could result in a potential barricade situation with law enforcement. When I look at the deadly force review panel that reports and talk about how mental illness is an underlying factor in a lot of deadly force incidents. So I think that the likelihood of there being increased confrontations between law enforcement and these respondents is going to go up. We've already seen it with the yellow flag, and where we're having to bring in additional resources to try to safely resolve those calls and safely execute the orders. And I anticipate, based on this, that we'll need to do that more, and we'll need additional resources and personnel.
Senator Talbot Ross?
Thank you, Madam Chair. I want to emphasize again that we appreciate you being here, Lieutenant.
Thank you.
Since the tragedy in Lewiston has been brought up a number of times, and you cite some data based on it in your testimony, with what you know, did the family in Lewiston go to any branch of law enforcement?
So I'm only aware of public reporting and what the commission report put out, but I don't know enough about the commission to really want to speak authoritatively about it here at this hearing. So I don't know if the question is, did Robert Card's family approach law enforcement prior to Lewiston? I know there has been some reporting, and there was a Saginaw Sheriff's Sergeant that was involved. So, but I don't know enough for sure to be able to definitively say it here at a public hearing to be able to say yes or no, because I only know about some public reporting and what's kind of filtered to me through my department.
I was going to have a follow-up question, but you finish.
Yeah, my follow-up question is, if I understand your testimony well enough, you've stated that by adopting this bill or IRPA, it could be confusing to folks, and you didn't see it as an additional tool for family members. And so, if the family in Lewiston did approach law enforcement and law enforcement did not do anything, therefore we had that tragedy, would you not then agree that having an additional tool for family members to prevent these tragedies would make good sense?
Well, I don't know if I should be going back and saying if we had this. I mean, we had the yellow flag law. One thing I do know is that to address an identified issue by the Lewiston Commission was the protective custody assessment warrant that was passed by the legislature last session. That is certainly a helpful tool that they've added the yellow flag, where we now have a protective custody assessment warrant in those situations where we're unable to access or have face-to-face encounter with the respondent. So I think that would have been helpful at the time of Lewiston, as I understand it, with Robert Card. but I don't know if that had been in effect and the law had been followed at the time, if it would have prevented it. I don't know if the yellow flag was enough at the time. I don't know as I feel comfortable saying if we had a red flag, that situation would have been prevented.
I'm just curious about your response to the prior question. It's curious to me that you're only aware of some reporting regarding the history with Mr. Card. Have you not reviewed the report of the commission on the Lewiston shooting?
I have. I read the interim report, and I know that was pretty pointed in terms of the criticisms of law enforcement response related to the sergeant. I just don't know specifically dates and times if the Robert Card family reached out to law enforcement. I just know that there was certainly some criticism of the sheriff's deputy that went there.
Thank you. I wasn't looking to criticize anybody. I was saying that those facts are all laid out in the report. Thank you, Senator Carney.
I don't have a question.
Okay. All right. There are no further questions. Thank you for your testimony.
Thank you.